Okay, so I think we're going to go ahead and get started here. With us, our first speaker today is going to be Chuck Audie. He is from Geary County, and he's kind of an expert in contracts and different things. He's a mentor for a lot of us. So he's going to speak to us first about how to get things done correctly.
All right, Wendy, I'm going to take that as my cue to get started here. Thank you for letting me join you virtually today. It's here in Geary County right now. We've had a little freezing drizzle and a little sleet and a little snow, but they say the big stuff's coming tomorrow night, so I guess we'll see what happens. Leases are very, very important in agriculture. Very few Kansas farmers own all the land they farm, so many of them will have multiple landlords, multiple leases. Over the years, I found that a lot of people have a lot of misunderstanding about what is and isn't in the Kansas Ag Lease law. So want to kind of hit a bunch of important points on that and kind of hit the high points of a few other things that come up with leases and ag land. And if you have really detailed questions, hold them for Roger McCowan that comes on the next hour because he is an outstanding speaker. So a couple of disclaimers. I'm not a lawyer. I've been an extension agent for 39 years. I've spent decades working with producers and landlords on leases. But if you get into a landlord-tenant dispute, hire a lawyer. Don't call me up. I can't represent you in court or before a judge. But a lot of these things, all these things are right out of the Kansas statutes, and a lot of them are right out of a K-State bulletin that I will reference at the very end of my program today. Everyone always wants a fair lease. That's kind of a misnomer because fair is a judgment call. We need to be talking about equitable leases. Equitable is an economically definable term and should be what we're aiming for. A lot of people will use fair and equitable interchangeably, but there really is a difference. One of the things that everybody out there knows, in ag production, there are years that crops and fields will not make a profit, and leases should reflect that. If one party in a lease is always making or losing money, the other party is not, it's not an equitable lease, and it needs to be examined and fixed. And my last disclaimer is, it'd be great if we could have one standard lease for every single field that you farm or for every single field across a county or a state. That's not the way it happens. Every field is different. So sometimes while you may want to have a uniform lease across fields in a lease, you may want to have individual field-based leases just to take into account the natural variability that we have. In Kansas, there's essentially, we'll call them 3 leasing practices. I'd say 2 and then one other one. We've got cash lease arrangements. 30, 40 years ago, there weren't a lot of cash lease arrangements outside of pasture leases. Most everything was a crop share arrangement. In a cash lease, landowner receives cash, tenant accepts full risk and full management control. 100% of the crop is the tenant's. In a crop share arrangement, landowner and tenant share in input costs as well as a share of the crop. There's going to be sharing of the management responsibilities as well. Then the last one is custom farming arrangements. I have seen a few of these over the years, and it's usually when somebody is sort of easing their way out of being an active farmer, and they're not quite ready to give up control yet, so they hire a neighbor to start doing the things they can't do, and eventually it turns into just a full regular crop share or cash lease arrangement. We have written leases and we have oral leases. Both are legal and binding in Kansas. A written lease is generally determined exactly how the lease is going to occur. It can be very, very specific. It is my preference to have a written lease for reasons I'll get into numerous times through my presentation. In absence of a written lease, Kansas law says that there are oral leases. But the minute you go to an oral lease, the state assumes a whole lot of things. Cropland and pasture land are treated the same. By Kansas statute, an oral agricultural lease is 1 year in length, and it automatically renews until it is properly terminated. There's several things about proper termination. I'll get into that. So oral leases are a 1 year automatically renewing lease until they are terminated or changed or replaced by a written lease. A landlord and a tenant can agree to absolutely anything in an oral lease. As long as everyone is in agreement and getting along, it's no problem. And I know I know some very complex oral leases that have been working for decades. However, if a problem develops and the case goes to court, the court doesn't care what was said before the handshake. They're going to defer back to what the statutes say. And that's when all of a sudden people start losing control of their land or their crop. Leasing issues are somewhat complex. There's a lot of different statutes, a lot of different parts of Kansas statutes that go into that. You've got property law, right of possession, right to harvest crops, improvements, noxious weeds, liability, assignment of leases, non-payment. There's also contract law, statute of frauds, personal services contract, termination of tenancy. We're going to hit highlights on every single one of these. Keep in mind that a lot of these statutes that have to do with ag land are the same statutes that impact someone renting a house or renting an apartment. So some of the things may seem a little bit weird, but you need to be aware that they apply to ag land as well as residences. One of the first and foremost things that I want people to be aware of is what's known as the right of possession. The landowner conveys to the tenant the right of the possession, and in the eyes of the law, the landowner cannot use land for their own purposes unless those rights are retained in a written lease. And that includes who hunts on the land, who fishes on the land, whether trees are harvested. Now, there's a lot of oral leases where by agreement, the landowner still controls who's hunting, who's fishing, those sort of things. But if push comes to shove and it's not retained in a written lease, the landowner can lose those rights, and I have seen it happen. The tenant has full right to farm the land as they wish. Double cropping after wheat, grazing residue, cover crops. These are all up to the discretion of the tenant if not in writing. Now, while it's up to the tenant, if the tenant wants to remain a tenant for more than just 1 year, it is important for the tenant and the landlord to discuss these things. If they don't and the tenant does something the landlord doesn't like, they're probably going to be off the land the next year. That's why I like written leases that can state yay, nay, conditions of use, all this stuff can be included in there. The landowner is limited by statute to very certain occasions when they can enter the premises. And if you think about this impacting a house or an apartment, it seems to make more sense, but it applies to agricultural property also. Landowner can only enter the premises to make inspections, make repairs, show the premises to prospective buyers, to collect rent, and to deliver notice of termination to the tenant. That's about all it comes down to. And like I said, an oral lease, we can get along just fine. Things go sour, and you've got to be aware of these things. Growing crops are generally considered the property of the tenant. If the tenancy is terminated after crops are planted, the tenant still has the right to harvest the crops. The crops are the tenant's. If the landlord dies during the lease, but before growing crops are harvested, the tenant still has the right to harvest the crop. Now, the heirs of the landlord, they're probably going to get the crop as long as it's not set up as a life estate. If it's a life estate, then once that landlord dies, everything is going to go into the estate, and then it becomes a rather, we all know how estates go. So that's the one big exception on that. Okay, let's take that into consideration, the right to harvest crop. Disposition of the crop is up to the tenant. In case of a drought, the tenant has the right to harvest the crop as forage or to not harvest anything at all. Several years ago, we had drought up in the northern Flint Hills here, and there were some tenants that decided they did not want to harvest any of the crop for any reason. And there were others that wanted to harvest it for forage, obviously. If it's harvested for forage for livestock that the tenant owns, the landlord certainly needs to receive some sort of payment for their share of that crop. And of course, the landlord, I just always encourage landlords to have crop insurance. Of course, on a crop shares lease, on a cash rent, it doesn't matter. but really they need to have that crop insurance. Improvements. The tenant is generally not entitled to remove any permanent improvement. What's a permanent improvement? Basically, it's looked at as anything fastened to the land. The example I use is one of several years ago where a tenant was renting a half-acre pasture, put in some underground piping, poured some nice concrete pads, put, frost-proof waters on top of those pads, fixed up some fences, put in some brand new gates. 2 years later, the landlord terminated them. Obviously, the underground piping, the concrete pads didn't go anyplace, but the waters were removed. The fence didn't go anyplace, but because the gates could be lifted off the hinges, the gates did go. So the tenant, of course, may remove personal items, equipment, portable corrals, panels, things like that. But anything attached to the ground, a pole barn is another thing that comes to mind. Those sort of things stay with the land unless an arrangement has been made in writing. Noxious weed. This is one of my favorites because I get a lot of questions from landowners usually about this. The Kansas statute says that the party that either owns the land or supervises its use has the duty to control noxious weeds, which means it's just wide open. Now, we generally interpret that the tenant has exclusive supervision of the land during the lease terms, unless it says otherwise in a written lease. But assuming that if the noxious weeds are not controlled and the county comes in and treats the noxious weeds, and then the bill isn't paid, it's going to be a lien against the property, so it's going to impact the owner. Noxious weeds, that's one of those things I think really need to be stated in the lease. It is the responsibility of the tenant to control the noxious weeds. If the landlord wants to provide the chemical and the tenant provide the labor, that's fine. But outline it, because it's up in the air, and the state's going to say it's somebody's responsibility. It's either the tenant or the landlord. The tenant is generally considered to be liable for any injuries to people, friends visiting him that are on the property that he controls. The tenant has responsibility to maintain leased premises in good condition. Landlord generally isn't liable to the tenant or third parties, but these are legal issues, so there are exceptions, of course. The landowner is going to be liable if there are undisclosed dangers that are not told to the tenant by the landlord. And the classic one of this is the old hand-dug well that's out in the corner of the North 40 that's covered up with half-rotten timbers, and nobody tells anybody about it. Drop a corner of a tractor tire in it. You can have a friend that's there hunting fall through it. Landlord knew it was there, did not tell the tenant. The landlord has a liability in this case. That's why I'm a firm believer that if you know of any old wells, hand dug or drilled, get them filled up. Just get rid of that risk. Conditions dangerous to persons not on the leased premises, low-hanging branches. We had a little bit of freezing rain up here in north of Junction City this morning. That can start to bring down branches. So you need to keep those back out of the way. Any part of the land that the landowner retains control. Quarter section, landlord still has, the farmstead, 5 acres up there in the corner. That's what the landlord controls. He's responsible on those 5 acres. If you lease premises for public admission, think of Woodstock. That's a classic case. Or if the landlord fails to make agreed to repairs, if the landlord knows of defects that were likely to injure known trespassers. Now, trespassing is illegal in the state of Kansas, but it is also illegal for landowners to set booby traps to injure trespassers. That's just one of those things you don't do. There have been court cases, numerous court cases on this. The landlords have lost virtually every single time. Call the law officials, let them deal with it. Leases can be assigned, subleases if you will. Statutes say that transfer or assignment of lease can be done without the landowner's permission if the lease is for more than 2 years, which means a 3-year written lease. Well, we can't have a 3-year oral lease, because oral leases are only 1 year. You can have a sublease situation on an oral lease, but you have to get the written permission of the landowner. Sale of leased property. We ran into this several years ago. We were having a bit of a housing boom here, 10, 15 years ago around Junction City. And there were landowners that were selling off 5 and 10 acres for people that wanted to build houses. And it was the 1st of May, and the new owners came out and started tearing up the wheat crop to dig a foundation. And the tenant came by and said, who's going to pay me for that wheat crop? And the new landowners had no idea. Leases go with the property. Unless there's something in writing between the previous owner and the tenant, the sale of it doesn't make any difference. The new owner takes a property subject to the existing lease. So then they have to serve notice of termination. If a property is sold, though, the tenant does not have to agree to be the tenant of the new landowner. They can say, hey, I'm going to harvest my crops and I'm out of here. I don't want to have this person as my landlord. Doesn't happen very often, but it can happen. There was a land sale in Erie County here just before the 1st of the year. It was in early December, and they had written leases that said the lease ends on, basically was the date of the land sale. Now, the new landowner kept on the old tenants to that extent, but this was a case where there was a written lease that said the lease terminates on this day. Non-payment of rents, there are provisions for if rent goes unpaid, landlord can have a lien on the crops growing or harvested from the premises. It's superior to prior existing security interest, attaches to landlord's share of the crop. This is one of those situations where probably need to get a lawyer involved just because of some of the stipulations that can go in there. Cash rent leases, it must be filed to perfect the lien. Livestock pasture leases, the landlord has superior lien against the livestock, and this is one where landlord must record a notice in the county where the land is located within 15 days after they're removed from pasture. So there's some real stipulations on here. If you're afraid you weren't going to get paid for renting to some pasture to somebody, why did you rent it in the first place? But that's another story. Things happen sometimes, and just be aware that you got to really be on the ball with those pasture leases. If the tenant fails to pay rent for at least 3 months, basically 1 quarter past due, landowner may terminate the lease with 10 days written notice. Doesn't matter what time of year it is. And the tenant can simply pay up the past rent and then cancel that. But it's there. Be aware of it. Statute of frauds, and this is where we get into the oral leases. Statutes say that contracts must be in writing to be enforceable, especially those conveying an interest in real estate. There is an exception for leases that last for a term not exceeding 1 year. Thereby, oral ag leases run March 1 to March 1, renew each year under the same terms, unless they negotiate a new term or the lease is replaced by a written lease. If landlord and tenant sign a new written lease, it immediately comes into effect, and you don't have to worry about the March 1 and all that. Oral ag leases are an enforceable exception to the statute of frauds. If the landlord dies, the landlord's heirs generally assume the responsibilities of the decedent. Remember, we said that the lease goes with the land. If the tenant dies, what often happens? Somebody else in the family takes up the farming operation and they continue to farm it. But some courts have said that a lease contract is a contract for services of the tenant and no one else. If you are a tenant and you have other family members, a brother, a sister, a son, a daughter, a niece, a nephew that's farming with you, that may be sort of starting to work their way into the farming operation, get everybody's name on the lease. That way, if one party passes, you still have the other people that are on that lease. So then you don't have to worry about all that. Another reason to have a written lease. This is the one item that I probably get more questions on. I've already had 6-8 questions this month from both landowners and tenants about termination of tenancy. There are 3 conditions that you have to take into consideration that must be met. Termination notice must be written. It must be in writing. The notice has to be given at least 30 days prior to March 1. And now that's not just postmarked 30 days prior to March 1. That is in the tenant's hands. The notice must specify that the lease terminates on March 1. 3, very simple. It can be kind of confusing at times, but and everybody seems to wait until January 29th to do these sort of things. You could give notice on March 1 of 2021 that the lease is going to terminate on March 1 of 2022. It doesn't say that it has to be 30 days prior. It has to be at least 30 days prior. This year, 2021, it's a non-leap year. 30 days prior is January 30th. In leap years, you get an extra day. It's January 31st. In the Kansas Ag Lease Law bulletin that I'll reference at the end, it has a sample termination notice. It's very simple and straightforward. It is generally felt that it doesn't matter whether the tenant is going to stop renting the land or the landlord wants to change tenants. Notice needs to be served. It's not just one way or the other. And it should be written. Now, there's a lot of oral leases that are terminated all the time. Just, I just can't farm it anymore. I'm going to stop farming, and everybody's good to go. But to be enforceable, and that's where these come in, is that the landlord is not happy with the tenant, or they can't come to new terms. So that's why we do these things in January, so that if they can't come to new terms on an oral lease, they have time to serve proper termination of tenancy. If there is a written lease, the terms in it, that's what it could be, January 1 to December 31st. That's fine. If it's a written lease, but there are no dates specified, it defaults to March 1. You can just decide, that's fine with us. And I know a lot of written leases that say March 1. If that written lease is, say, a 3-year lease, and at the end of the 3 years, the landlord turns to the tenant and says, let's just keep going the way it is. That's fine. It automatically becomes like an oral lease, and it keeps renewing annually. If you just extend it once, 1 year, it becomes an annual, and then you have to go back to those 30 days notice prior to termination, still required. 30 days prior to the date that is on the contract, if there is one. If it says January 1 to December 31st, and after 5 years and a 3-year lease, you decide, okay, I'm going to terminate this tenant, then it has to be 30 days prior to December 31st. There are some certain considerations that we need to talk about. If there is a fall planted crop, generally it's going to be winter wheat, could be winter barley. If any normal preparation, we used to say planting, but now it's been kind of through some court cases, any normal preparation, starting with herbicide burn down, if any of that work has begun, then the tenant still has the right to harvest the crop off that. So if notice after normal preparation for wheat ground planting, lease on the portion of the ground in that winter crop ends on the day following the last day of harvest or August 1st, whichever is earlier. I can think of one time since 1982 that wheat harvest didn't end before August 1 around here. That was the flood year of 1993. Now, if notice before normal preparation for wheat ground planting, lease ends on March 1st. So if July 1st or even June 1st, the landlord serves termination notice to the tenant, it goes until March 1, but it's before any start has been made on the normal preparation for the fall wheat planting. If the tenant were to plant wheat after that notice is given, the tenant does not have the right to harvest it. Fall seeded perennial crops are another situation there. If notice after obtaining satisfactory stand of alfalfa, and I guess it could be brome grass too, or fescue, but if notice after obtaining a satisfactory stand on the year of planting, then the tenant must be reimbursed for the seed, the labor, the fertilizer, herbicide, all of that went into it. If the landlord just waits until a year after, They don't owe anything. I would like to see a prorated payment, though. We normally figure that these crops are going to have a minimum lifespan of at least 4 or 5 years. But if you just wait a year, so if the crop was planted in the fall of 2020, notice was given today, then the landlord would owe the tenant for all that expense of planting that alfalfa. Wait until January of 22, he's home scot-free. So if I was a tenant planting alfalfa, I would make sure I have a written lease for at least 3 or 4 years. Okay, the only test I'm going to give you today, just a quiz on termination of tenancy. Notice is given on February 1, date set on March 1, no fall seeded crops on the ground. Is it a legal notice? No, it was not 30 days prior to March 1. If it had been January 29th, no problem. Okay, notice given on January 15th, date set March 1, wheat seeded on half the ground. Is that a legal notice? Yes. The portion not planted to wheat terminates on March 1. The acres planted to wheat terminate on the last day of harvest or August 1st. What this precludes you from doing, or precludes a tenant from doing, is on those acres going in and planting a double crop, soybeans. They can be planted, but you're going to have to seed them in by air, and then you're not going to be able to harvest them. So just if there's wheat planted day after the last day of harvest or August 1. But I think day after the last day of harvest is going to catch it 99 years out of 100. Termination of tenancy. Notice of termination should be served on tenant personally. This is very uncomfortable for a lot of people. We as human beings in the Great Plains and the Midwest are not good with confrontation. I know friends from the East Coast that don't have a problem with confrontation, but we tend to do anything to avoid confrontation. So you send it as certified letter. If that doesn't work, you can hire someone to serve the notice of termination. The law also states that a copy of the notice may be left at tenant's usual place of residence. It may be delivered to a person over age 12 who resides on the leased premises. Leave it with a teenage son or daughter. The notice may be posted in a conspicuous place. That's all the statute says. It doesn't say where that conspicuous place may be. Is it on the front door of the tenant's residence? Is it on the front door of the sale barn? It doesn't really say. The notice may also be sent, as I said, by registered mail to the tenant's usual place of residence. There's been cases where there have been legal notices put in the newspaper because nobody knew for sure where the tenant had left. Small tracts of land here around Fort Riley, that sometimes happens. So those are some of the options that you have. It's a lot of times, if it's gotten to this point that it's being terminated, it's a very contentious situation. And I can understand why nobody would want to go in person to deliver it. If you do, you may want to take along a spouse, somebody with a cell phone so they can video that you did hand it to them. That way you've got proof of it. Okay, a brief summary before we move on to some other areas. Legally, a lease conveys property rights to the tenant. In case of an injury, the tenant may be responsible, is likely responsible. Landowner isn't necessarily out of the woods. Always make sure you have talked to your insurance company. Cover all the bases. Written leases can be exact, very exact, but oral leases are subject to state law and court interpretation. Very specific rules guide lease termination. Common sense holds. Communication is so important, and you're going to hear me say that several more times before I'm done here. Communication is very important. Okay, what are some of the basic principles of good crop share leases? Yield increasing inputs should be shared, including fertilizer and lime. Fertilizer almost always is. Lime is still, shows up on several of my slides. Share arrangements need to be adjusted as technology and land values change. Land values went shooting up over the past 10 years, and they kind of peaked and went back down. You got to make some adjustments there. Total returns are divided in the same proportion as what's contributed. Needs to be compensation for long-term investments, good landowner-tenant communication. And it's not just one or the other, it's both of them. It's both. Sit down, talk on a regular basis. What do the two parties bring into the crop share arrangement? Well, the landlord's got the land. That's the crucial part here. The tenant often has the labor, the machinery, fuel, seed, fallow period herbicides, and or tillage. Common share arrangements are not dictated by Kansas statute, contrary to what some people think. I've had phone calls where they said, Chuck, what do I have to share? The law views this as a negotiated contract. Everything is on the table. Now, what a lot of people think is law is simply convention or historical precedents. Commonly shared inputs, fertilizer, lime, herbicide during the growing season, insecticide, fungicide, tech fees, if you can break those out of the price of the seed nowadays, it's getting harder and harder, and then insecticide and fungicidal seed treatments. These are all things that we know are yield increasing costs. I have seen all of the items on this slide where sharing varies, shared or not shared. Herbicide application, burn down herbicide application, burn down herbicides, lime, seed, harvesting. There are justifications for all of it. The crop should be shared in the same proportion as the inputs are shared. And then likewise, government payments shared the same as the crop. You go into the FSA office, they say, okay, this is a shared field. What's the shares? To determine the shares, decide what costs are being shared. We're going to share fertilizer, set those costs off to the side. Take all the rest of them, total those annualized costs up, and then see what percentage is the landlord's and what percentage is the tenant. This then sets the ratio. But what often happens? The landlord says, I want a 1/3, 2/3 lease. Here's what I'm going to share. It comes into it backwards. And that's not the way these things should be done. And I'll talk a little bit more about figuring out those crop shares here in just a couple more slides. Cash rental considerations. I'm going to show you 3 slides that are from the National Ag Statistics Service, survey done late last summer. They do this every year. There is one number given per county. I've got one slide for non-irrigated, one slide for irrigated, and for you and all you folks in Southeast Kansas, we're out of luck on that, and then one for pastures. You've got to think about the variation in land. I mean, here in Geary County, we've got some rocky old knobs up on top of these Flint Hills. We've got some really good first and second creek and river bottom. Everything gets lumped together. Some responses to these surveys are leases that were set up 10, 15 years ago and they haven't changed. And others are going to be leases that just happened this year. Always remember, survey information is only good as the responses received. You go to agmanager.info, go to land leasing, land rental rates, you can find this bulletin. They're right there. That's a good website for a lot of other information as well. Here we go on the non-irrigated cropland. Now I'm here in Geary County, so we'll use that as the example. It says $59.50 per acre. Well, when I'm talking to people, especially on some of these better creek and river bottom land, I'll guarantee you it's going more than $59.50. It's going $85 and higher sometimes. But I also know some of these leases that are $50, $45, $40. So in the end, it's an average. It's an average. It also gives you a starting point. If somebody came in and said, hey, I'm looking to rent some land for $150, I may shake my head, but it's like, hey, if you can get it, go for it. Or if you're willing to pay that much, that's fine. But, it's a starting point to work from. As you can see in this one on the non-irrigated cropland, there's a lot of counties that don't have anything listed because either most of the irrigated ground isn't leased, it's owned, or there simply aren't enough people responding to meet the minimum threshold so that you can't identify any one operator from that information. Ag Statistics has a very strict criteria that they go by. And then pastures. You know, right now I'm telling people in the Northern Flint Hills in my county, you should be looking at $26 to $28 per acre. This says 21.50. Well, I had a landlord call me a couple of weeks ago that said they were getting $15 an acre and they suspected it was a little bit low. I told them they were right. It is a little bit low. But you take that $15 and that $28 and average it out, it comes right out at 21.50. So it's a place to go by. One of the things I'm sorry, I got ahead of myself here. If you're switching from a shares lease to a cash lease, start with a known point. What have been your returns the last 3, 4, 5 years? Especially if you're a landlord, look at what you've been getting after all the expenses have been paid. Land taxes are a fixed cost. We're not going to put those in here. We're just looking at the variable costs. Also remember, landlords do not receive government payments on cash rent. Now, the one that I was going to talk about a second ago. I always like to look at state by state. And remember, when you look at that those Kansas numbers, you know, that goes from Donovan County to Morton County, from Cheyenne County to Cherokee County. So you've got in these plain states a real change from the east to west. So on average, non-irrigated land in Kansas was $56 an acre. I'm originally from Nebraska, grew up in York County, Nebraska. $149 an acre. You can just look at that. So if you think that our lease rates are high or low, I don't even include, I just put the surrounding counties, states. I don't even bother to put things like Florida and California in there because those will just blow your mind. I think California this year was around $400 an acre, but they're growing very different crops. So keep in mind, garbage in, garbage out. If you get a lot of people filling out these surveys honestly, you're going to have good data. I get calls all the time from people wanting to know, what's the going cash rent, Chuck? The problem is nobody wants to tell. Everybody wants to know, but nobody wants to tell. I know for certain exactly one cash rental rate, and that's my wife's family farm that we live on now. I know that one because I help negotiate the lease every 5 years. Everything else is just people kind of hint around at things, but they don't tell me. Surveys give you a starting point on cash rents. Take into consideration all the intangibles that are also going on by the landlord or the tenant. Those need to be taken into account. Lastly, on this topic, if someone asks you to complete a survey, please do it and do it honestly. There's a lot of us, including some of your neighbors, that depend on this information. And the more data points we have, the more honest and upfront you are, the better this is. Got to get a little bit of Chuck's opinion in here. Most crop share leases are not equitable. I've already talked about that. The landlord tends to say, this is the share I want, this is what I'm going to share on. So that we work into them backwards. If cash rental rates go up in good times, they have to go down in the not so good times. There were some pretty high cash rental rates being paid here 6, 7, 8 years ago. And it was really hard for a lot of landlords to bring those back down when everything came tumbling down. But they have to do it. There's also going to be those unknown impacts. It may be a trade tariff like we were looking at the past year or two. It may be a drought. It may be a flood. As a landlord and a tenant, you've got to be in communication and work to make adjustments. It's just, we all know the nature of farming. Where it gets really tough is when all of a sudden you've got an heir that's 3 generations removed from the farm that doesn't have a clue. And I get my fair share of those phone calls too. Where to get help. K-State Extension Ag Economics has a Excel spreadsheet called KSU Lease. It is a great program. If you're comfortable with Excel, you can take a day like today when it's kind of cold and nasty outside and sit down and play a lot of what if scenarios. You can put in your own cost of production, or you can put in regional averages from farm management, and you can play around with sharing different cost share arrangements and see how that changes things. And it also will give you an idea of where you should be looking at if you want to start on some cash lease in situations. www.agmanager.info. Type KSU Lease in the search box on the upper right-hand corner. Go to that page. There's also one on grazing decision tools. So I have sat down with more than one tenant and landlord and worked through this and then left the conference room, closed the doors, and let them talk it out. And it works really well if the landlord and the tenant can sit down together on these. Just one quick slide on farm bill considerations. March 15th is the deadline this year. Thank goodness we get to re-sign every year right now. My general rules of thumb, and you all know about general rules of thumb. Sometimes you're right and sometimes you're wrong. But if you think yields are going to tank, look at it going ARC. If you think prices may tank, look at PLC. With current new crop prices and average yields, there's a good chance that neither one's going to pay in 2021. Talking with a couple of our ag economists, there's a little bit of a lean towards PLC on wheat, little bit of a lean towards ARC-CO on soybeans, and that's as of right now. That could change tomorrow. Corn, grain, sorghum, it's up in the air, but just at least we can change it every year. Keys to a successful lease: communicate, 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 and then put it in writing. I don't know how many times over the years I've sat down with a lady on the phone or in my office who has lost her husband in the past year. And now all of a sudden she has to take care of the leases. And she has never had any input on the leases. She has no idea what the leases have been. Simply having some things in writing would take care of this problem. And if there's, heirs on either side, landlord and tenant could decide they want to go down the road 3 miles, take a look at the crop growing, and get hit by a Mack truck, and both of them die. Sad situation. But then the heirs are going, where do we go from here? Nobody to turn to. Get it in writing. It's not because we don't trust anybody. It's because we're all mortal and we can all die tomorrow. A couple quick ones on pasture lease considerations. Landlord, tenant, a lot of times the landlord provides the fence materials, tenant provides the labor for those repairs. Landlord may provide the weed and brush control herbicides. Tenant may decide they want to spray them. I've got some pasture owners up here that love nothing more than to spend 2, 3, 4 weeks in the spring tooling around the pastures on their four-wheeler and spraying musk thistle. Great, knock yourselves out. Application of fence replacement needs to be discussed at some point in time. Take into account all the items that the tenant or landlord does or doesn't take care of. The more the landlord is doing, if they're providing some service, going to be a higher rental rate. If the tenant is doing everything, it's going to be a lower rental rate. And sometimes it gets down to, the tenant's coming over after a big snowstorm and plowing out the driveway. They may be doing a bunch of other stuff around just to help out the older couple. I don't have a problem with giving those people a break. So they're putting in a lot of sweat equity. Pasture leases really need to be in writing, because otherwise the tenant by statute has that land from March 1 to March 1. They could run cattle on it the whole time, or sheep or goats or whatever. With a written lease, you can say going to come in April 15th, going to be out October 15th, or whatever dates you want to use. But I really like to have pasture leases in writing. 1 or 2 on the Kansas fence law. Kansas is a fence-in state. We are not open range. Livestock owner is responsible for keeping those animals contained and off the roadway. Contrary to what so many people think, there is nothing in the Kansas statutes about adjoining property owners, meaning at the middle of the fence and the part to the left or the right is yours. What the statutes state is that building and maintenance is to be in equal shares. Figure out the cost, 50-50. It doesn't matter which side of the middle of the fence it's on. So just keep that in mind. There is a provision in the Kansas fence law that basically says one landowner can't force another landowner to pay for a partition fence. There's a whole lot of just considerations in there. And it gets into using otherwise than in common, and it's a mess. I've gotten in on some of these, and what I tell people is figure out a way to contribute your half of the cost. If you're the large property owner, and luckily we get a lot of these small property owners that are along this large pasture because they want their 5, 6, 10 acres out in the country. And a lot of times I just tell the adjoining property owner, let them know what it is. Let them know they can help pay for it if they want to, but just figure you're going to pay for the whole thing yourself. Is it fair? No. Is it equitable? No. but sometimes it's just what you have to do because it's the the livestock owner's responsibility to keep the livestock in. Couple of common questions. When should cash rent be paid? I feel like there's got to be something up front. If you're a landlord and you have a younger tenant, sometimes they can't pay the whole thing up front. But maybe get a quarter of it, a third of it, and then have the rest at the end of the year. Set it up on quarterly payments. There's a lot of ways to do that. Whatever works out, but I really like to see some money paid up front. Talk about written leases. Written leases do not need to be complicated. All that really needs to be in them, names of the parties, description of the property, that's where you can use the legal description, number of acres, what's the time period, from when to when, special terms, limitations, access, hunting. If it's cash lease terms, when's the payment due? If it's shares, what are the shares and what's being shared on? And then the signatures. And like I said, if it's a couple that are the landowners, have them both sign it. If there are other family members involved in the actual tenancy of the farming, have all their names on it. It just makes it so much cleaner in the end. If somebody wants some samples, some examples of some simple cash leases, email me. I've got them as Microsoft Word documents. I'll be happy to share them with you. We've got two really good publications I've talked about, Kansas Fence Law and Kansas Agricultural Lease Law. Those are available at the ksre.ksu.edu website. They're available from your local extension office. I already mentioned that KSU lease spreadsheet. Don't hesitate to contact your local extension agent. Get them involved. They're going to be, your boots on the ground, especially if you're an out-of-county property owner. Visit with them. Find out what's going on right now. What are prices doing? Do I need to be sharing on more expenses? These sort of things. Talk with your local extension agent. And that is, I hope to get through it in 45 minutes, and I think I have. I'll stop sharing. I'll leave this up for just a second, but that's my office number. My email is caudi@ksu.edu. I take phone calls from out of county. Sometimes it's more comfortable talking to somebody that you don't run into in the local extension office every time you go in there. That's fine. We all get that. We understand that. So email me, call me, be happy to visit with you. And I'm going to stop sharing now and go back. And Roger's been on. So being on the program before Roger McCowan talking about legal issues makes me very, very nervous. But hi, Roger. I hope you're doing well. Questions now. We've got until, I think, 2 o'clock. You can put them into the chat box or turn on your mic, or if you're there with Wendy in the building, you can tell her and she can pass them on to me. Everybody's hesitant to talk about these things, and I understand that. That's why I said if you want to call me or email me, great, do it. Wendy, I'll let you decide how long you're going to wait.
Sorry about that. We do have a question. We do have a question here in the building.
Okay.
Do you want to go ahead?
There was last year in Montgomery County, there was a guy tore out a fence, and the other landlord said, no, the fence is good enough, and they went to court over it. The other landlord, owner of the property, ended up having to pay half of the fence, even though the guy just wanted a better fence, to get it. Is there anything like a ruling like, okay, just move in 6 inches on your property and build your own new fence that you want, leave mine alone?
There have been spite fences built for a number of years. When you get into that fence law thing and that not wanting to have to pay for your half, that's where you really need to get an attorney. There is some case law, and it's just get an attorney. You're going to be better off in a case like that. And Roger, maybe in his section we'll talk about some of those case laws. I don't know, but yeah, fence law is a challenging one. Oh, he unmuted his mic. Go ahead, Roger.
No, I just unmuted my mic. I'm just listening.
Okay. Other questions?
Thank you.
Okay, James?
I will say I've got all these slides. I posted on a website. I think Wendy and David and James all have the URL. If not, email me and I'll send it to you. They're not in pretty color. They're just black and white, but put them out there. I've been doing this program for over 20 years. Every year I have to update it a little bit, but it's a lot of common sense. And I just want to say again, communicate, communicate, communicate.
Thank you so much, Chuck. Talking about stuff. Are you doing that?
Where'd you go? Hey.
There you are. So next up we have Roger McGowan, and he is the Washburn Professor of Law. He's pretty much he's a professor for a lot of stuff, honestly. So I think in a classroom, it looks like a really about to take a class on your degrees in. And really he helps us extension agents out a lot, going through all the various law issues. I mean, this time of year, it's one of our main questions when you're dealing with agricultural law. And so thank you so much, Roger, for coming out and talking to us today and helping extension out over and over again. I don't even know if you have an extension appointment, but you sure do help us out a lot. So thank you so much for doing everything that you do and here today as well.
Oh, no problem, James. My pleasure. And it's good to see Chuck. Chuck's been a superb agent for many years, and it's good to see him. If it's just on computer, it's still good and good to. I caught the last part of that. I've been chainsawing brush all morning long, so I thought I'd come inside this afternoon and do this. I actually have another one right after this. James, can you give me the capability to share the screen? It looks like I do have it now. Put my slides up there for you. And I did send the PDF hard copy to James so that it can be distributed to all of those that are on today. But it is a pleasure to be with you. Here's my contact information. Feel free to email me anytime. I also have a K-State address, but for fear that I would not pull it out by memory, I didn't put it up for you, but just use my law school one. That's fine. There's a lot of information that's available for you on the website, and I also use Twitter and all types of social media for educational purposes. You won't find anything other than educational information on my website or on Twitter. And I appreciate Chuck's comment there at the end about resources in the county office, which remind me that I probably should send over to Rich Llewellyn at K-State the updated Kansas Ag Lease Law and Fence Law publications, because those are on my website. I need to make sure that K-State has those. And I'm not sure all the agents are tapped into my website. So we'll see if I can do that. Then we can get those old publications out and the new ones in. I rewrite those sometimes twice a year when there are new cases, new developments that come out. So I'm glad you put that up, Chuck, because that did remind me that it is in a different location and you guys might not be aware of that. Just to give you an idea real quick of the type of agricultural courses that are taught at the law school, if you would happen to have a family member or know someone that would have an interest in ultimately going to law school and getting into a rural practice, where with the rural law program, we have a big emphasis on trying to get well-trained attorneys on agricultural issues in the rural areas that are really underserved, particularly out in the western third of the state. So if you do know anyone or you have an interest in that, please let me know. And in fact, when I was chainsawing this morning, I had one of my law students out here who's from Montana. They came all the way from Montana. I spoke in Montana a year and a half ago, and that's how I met him. And by virtue of that, he ends up at Washburn, and hopefully will end up in a rural practice at some place in Kansas or elsewhere. But a whole host of agricultural courses. It's probably the most comprehensive and vast array of ag-related courses that a student can take at any law school across the country, and we're pretty proud of that. And I teach a number of those. I'm teaching the general agricultural law course this semester for the law students. I'm teaching an undergraduate course in agricultural law at K-State this semester, also starting next week. Well, again, we'll probably overlap with just a little bit of what Chuck was talking about. I did review the slides so that I had an idea of what was already covered so I can move through those things. But very important point that he was emphasizing there, and I want to reemphasize it here. It's always best to put leases in writing. And this is the time of year with the time frame coming up for serving notice of termination at least 30 days before March 1. We're getting close to that deadline now, and I've had a lot of those calls and had to draft some lease termination notices over the past week, probably a half dozen of those. I've got another one to do this evening after I'm done speaking today. And it's always best to put leases in writing. And I know there's that trust issue. I hear that all the time. Well, if I put the lease in writing, perhaps the tenant will think that I don't trust them, and we don't want to have that happen. Well, it's not really a trust issue. It's an allocation of risk and reward. It's trying to avoid problems with the tenant. We always want to try to avoid that. And so what we're trying to do is avoid those problems. Not that we don't trust someone, but we don't want to get into problems with someone that we do trust. We don't want to break that relationship. And if you approach it that way, that may be a good way to broach the topic and the potential issue of that you don't trust me. But there are various issues to think about when you do put a lease in writing. We want to think about the right of the tenant to remove fixtures. If it's a permanent improvement, a permanent fixture that the tenant puts on, that becomes part of the real estate. And of course, the landlord owns the real estate interest, not just possession, but they own the actual asset. And so if it is a permanent improvement or as opposed to a removable fixture, then the landlord owns that. Landlord's right of entry, as Chuck pointed out, landlord does not have a right of entry in a written lease because possession goes with the tenant, and the landlord would have to reserve that in a written lease. Then, of course, we'll talk, I'll reiterate again what's been said about lease termination. Can you assign a lease? Technically, no. The tenant cannot assign an ag lease. We get into those issues in Kansas, particularly with respect to pasture leases, because it's quite common for a tenant to run somebody else's cattle on the leased premises. That's not really an assignment. It's just kind of a side agreement. It's often oral, but there is a clause if push comes to shove in Kansas law that disallows a tenant from assigning their lease absent the landlord's permission. And then weeds, of course, I noticed that Chuck talked about that in his presentation. And if you have a written lease, you want to assign the party who is responsible to control the weeds, because ultimately, while both parties are responsible in the oral lease situation, it's going to come back to the landlord as the owner of the property if the county has to take action, because they will assess the cost of any weed control against the tax records of the county. And that can create a problem between landlord and tenant and sever that relationship or create a fracture in that relationship. So if you have a written lease, you want to have a clause in there that deals with weeds. Liability for rent in the event of a natural disaster, an act of God clause. Another one this year, this past year, that we really hadn't thought much about is, and we really hadn't put these in leases, but it really came back to bite farmers hard in some instances, particularly hog farmers, dairy farmers, but it also did have some impact in grain markets. The result or the impact of the virus and then state governor mandated shutdowns of businesses as a result of outbreaks. We saw that with contract production, where you would have various plants, processing plants that were shut down because of a virus outbreak. And so you didn't have any place to market for example, your 300-pound fat hogs. Well, what are you supposed to do in that situation? Contract didn't deal with that issue. That's not a natural disaster. That's an act of government that prevents performance under the contract. I suppose I hadn't heard of it, but we could have the same thing that could possibly occur if a grain elevator has to shut down and you can't market your grain. But with fungible goods, such as live animals that need to be marketed at a precise time, or milk that has to be marketed at a particular time before it spoils, we saw dairy farmers that couldn't get milk to a dairy plant because the it was shut down due to an order of government. Well, that brings up what's known as a force majeure clause. And so that's something that we really hadn't thought about before, but occasionally that comes up. What is the tenant's right to harvest the crop if the land is sold or the tenant dies? Another thing that you want to specify in a written lease. If it's an oral situation, then that brings up what's known as the doctrine of emblements, the right to what's called an away-going crop. And does the tenant have the right to harvest that or not if that land is sold? If the tenant dies, can the tenant's heirs step in and assume the lease and just kind of sit on the premises until they receive notice of termination? What happens if the landlord dies? Well, that's an easier situation because the landlord's heirs will step into the shoes of the landlord, and they bear the responsibility to terminate the lease if the lease is to be terminated. If the tenant dies, it's going to depend on state law. Not every state is the same. In that situation, most of the states will say that the lease is over when the tenant dies because the lease was for the services of the tenant, and those services are no longer there. That's why, and that's particularly the case with a crop share lease. Now, some states, such as Nebraska, will vary that result if it's a cash lease because they're saying, well, you didn't really select the tenant because of their services. That's only relevant if we're dealing with crop share. That's not relevant in the cash lease situation. And so that bears on whether the heirs of the tenant have the right to continue that lease until they get notice of termination or not. And so that's one of those that, to avoid that type of confusion, we want to put a clause in the lease that says what's going to happen if somebody dies or if the land is sold. Normally, if the land is sold, of course, as Chuck mentioned, the buyer is going to take subject to the existing lease. Those are some of those things that we want to get in writing. What happens if there is a growing crop at the time the lease is terminated? I had several of those to deal with this week. Tenant had prepared the ground last fall, seeded it to wheat. Now they want to terminate the tenant, and of course, Kansas law says with respect to the fall seeded grain crop, and it's very specific to fall seeded grain crop, then that lease doesn't terminate until the earlier of harvest, or the day after harvest, or August 1. So whichever of those days comes first, the tenant remains in possession. So that's basically what that is saying is if you have an idea that you want to terminate your tenant and they might plant a fall seeded grain crop, then you want to give notice in accordance with Kansas law in writing before they prepare that seed bed and put that crop in the ground. So that's a key point that trips up some people. Leasing is very important to agriculture. I'm going to skip through that, skip through the types of leases that are out there. Basically, when you look at the type of lease, that's just how the parties are allocating risk and reward between them. Some types of leases put more risk on the tenant. Some types of leases put relatively less risk on the tenant. So just a lot of things to think about in terms of the economics of the lease itself, in terms of how they're allocating risk. Also, from an estate planning standpoint, and this has been the past 6 weeks or so, and it's really heated up the last few days for me. What's going to happen with respect to estate planning, estate tax, income tax, corporate tax? Am I going to have to totally change my business structure around? I've dealt with two farm wives this past week that wanted to schedule a time to call me. They did, and their voices were breaking. They were so concerned about what's going to happen to their farm in both of these instances that's been in the family for over 100 years. What if that estate tax exemption drops to $3.5 million and we lose step-up basis? Well, that's a killer, particularly if we lose step-up basis. And I did a lot of farm media interviews this past week, and you can get to $3.5 million on 500 acres of Iowa farmland. And that's below the average size of an Iowa farm. Just the farmland with the average value at all classes of ag land, about $7,000 per acre. You're right there at 3.5 million with 500 acres. And that's not counting equipment, machinery, retirement funds, insurance, the house. That's not counting any of that. And then the proposal would be to increase the rate to 45% and then eliminate step-up basis, so that if the heirs ever sold any of the inherited property, they would have to pay capital gains tax. I don't know if you caught this yesterday, but Janet Yellen, the pick for the Fed, is now tossing about the idea of taxing unrealized gains, not realized gains, unrealized gains. It's just, and this has agriculture, of course, really concerned. And what's going to happen with input prices, fuel prices have gone up, they're going to go up. What's been done to Canada now, just in the past couple of days. So estate planning implications, big time concern right now. And where does a lease fit into this? Well, lease becomes very important in particularly post-death, post-mortem estate planning situations. First of all, pre-death, what does the lease, the type of lease, do to your Social Security benefits? Certain Social Security benefits are taxable once you get up above a certain level of earned income. And if you're materially participating under a lease, that's going to be earned income. Will it have an impact on the taxability of your Social Security benefits and increase the tax for you? What about post-death? Well, now what's going to come back into vogue if the Congress would decrease the federal estate tax exemption from its current level of 11.7 million down to, say, 3.5 million, which has been talked about, maybe 5 million. Then that brings in another concern, perhaps the use post-death of what's called special use valuation in a decedent's estate, so that we value the ag land at its value for ag purposes, rather than fair market value as of date of death. Well, to be able to do that, we need to have material participation share leases, both pre-death and for 10 years post-death. So that's a concern, because post-death cash leasing can cause problems in that situation, and it will cause a recapture tax to occur of that special use value, the difference in value between the fair market value and special use value of the land. That difference would have to, the tax savings on that difference would have to be paid back. So leases can make a big difference, and they're also, the type of lease is important for other tax provisions: soil and water conservation expense, 179 depreciation. We've got to have the right type of lease in place to be able to get those tax benefits, because a lease, a cash lease, is not deemed to be trade or business of farming. It's deemed to be a rental activity. That has implications tax-wise. Also for farm program benefits, you have to meet an active engagement test to receive, as the landlord, a part of the payment, part or all of the payment. If it's with a tenant, you would receive all of the payment because the tenant is farming. You're not going to get there with a cash lease. And so the tenant would receive all of the farm program benefits. That's where you would need some type of share lease where you're showing that you're at least actively engaged, if not materially participating in the farming operation. So you have a lot of concerns with respect to the type of lease across the board: tax, non-tax. Okay, I'll skip through some of these things. There is a distinction in the law between custom cutters and croppers. Custom cutters are independent contractors, usually. Very rarely do we see a weird set of facts where a custom cutter is treated other than an independent contractor. A cropper is not a tenant. They're not treated as a tenant if the landlord supplies the land and the inputs and controls the operation of the farm and pays a portion of the crop to the person that raises and harvests the crop. A cropper doesn't have any legally enforceable interest in the crop. They just have a right to get paid for their service. And since that's all they have no possessory interest in the real estate. And so there's no need to give them notice to terminate, because the notice to terminate is to terminate possession, and a cropper never has possession. A cropper is just an employee. They're a wage earner hired to produce a crop. And so we can get into those situations. I saw a case recently on that distinction between a tenant and a cropper. Most of the case law on this is pretty old, but in 2020 we did have another one of those. So you can get into these weird arrangements, particularly if you don't have the arrangement in writing between you and the other individual. There are some things that the tenant can be doing that makes it look like, for example, they might be a cropper rather than a tenant. Okay, the courts will always look to the intent of the parties based on facts and circumstances and parties' actions and whether possession has actually been given. That's how we distinguish between custom creditors and croppers. But a lease is an estate in land for a definite period of time that's fixed in advance. And if you have an oral lease, that definite period of time in Kansas is 1 year, running from March 1 to the following March 1. And so that's what an oral lease is. It's presumed to be a 1-year tenancy. If you don't give notice, it's just going to continue on under the same terms and conditions for the next year. And then you have to look to state law to terminate that. Let me give you an interesting one here from Louisiana back in 2000. And this did involve a written lease. So what it shows you is you can even have problems when there is a written lease. It's we don't practice law by having clients come to the office and we sit around the conference table and we pull out our crystal ball and we set it in the middle of the conference room table and we rub the crystal ball and we get perfect answers about everything that's going to happen into the future. We know exactly what to do and how to draft documents. It doesn't work that way. And this is a classic case illustrating that. The parties had a written lease. And it was a written lease for crops, and the plaintiff is the tenant. He leases ground from the defendant from Pennington, plants 406 acres to corn, and it gets entirely consumed by deer. Imagine that. And this is along the Mississippi River in Louisiana. What happened was there was a flood. The Mississippi River flooded. This was high ground adjacent to the river, and so all the lowland was flooded, and the deer's food supply, the berries and the nuts and so forth along the river were underwater. And so they migrated up to the corn and they found this 406-acre field of corn and they ate the whole thing. And the tenant sues to cover the lost crop. And the question was, what does the lease say about it? Well, the lease had an act of God clause, and that said that the tenant assumes the risks associated with an act of God. And the tenant was trying to say, well, this is not an act of God. It's not weather related directly, perhaps indirectly, but the court said, no, the contract language was pretty clear and unambiguous, and tenant was assuming all acts of God. And we're going to say that deer eating the entire field and consuming it was within the scope of an act of God. And the tenant tried to say, well, I wanted to put up an electrical fence and you didn't let me do that. And the court said, well, an electrical fence is not going to keep the deer out anyway. And there's no responsibility of the landlord to convey in the conveyance of peaceful possession the right to put up an electrical fence. So interesting case. It just teaches us, well, those are some of those things we need to think about. Maybe a force majeure clause and maybe a destruction by wild animal clause, something like that. On the hunting issue, if you don't have it specified or the right reserved in a written lease, then in an oral situation, the possessor of the property, whoever has possession and in a tenancy, that's the tenant, gets to say who hunts the ground. And so it's kind of a weird result. An owner cannot use land for the owner's purposes without the tenant's permission. Now, I would say practically what happens there, if you have an oral lease and the landlord has not reserved that right, if the landlord wants to hunt their ground and the tenant denies the landlord the ability to do so, that lease is probably not going to last very long. But the idea here is, look, the tenant is responsible for the lease premises. The tenant has to control who comes on the property and what they're doing on the property. And that also bears on the issue of who's responsible for maintaining fences on a leased property, and that's the tenant. The tenant is responsible, and the tenant's responsible for animals of the tenant that get out because the tenant is responsible for those fences. There was a bad case, the Reynolds case in Kansas in 2002. It was on Highway 69 south of Kansas City. I think it was actually in Miami County. I could be a county off, but it was over in that area south of Kansas City. And what happened was cattle went through a double box culvert underneath Highway 69, came up on the other side. There was a highway fence on the other side. There weren't any cattle over there, but it was just a highway fence. I think it was an orchard. And the cows got up and went through that, got under the road, came up on the other side, went through the highway fence, got out on the road, and motorist struck some of the cows. And in fact, an individual died in that situation. Long story short was landlord's not responsible. Because the tenant is responsible. And the case came down between the tenant and the state of Kansas. Tenant was eventually, tenant settled out. And then what happened was the lawsuit was against the Department of Transportation for failing to maintain the highway fence. And the Department of Transportation lost their argument being that we didn't have to have a cattle tight fence on that side because our highway fences are just there for purposes of restricting vehicular access to roadways. And the court said, no. That may be part of the reason, but you do need to have cattle tight fences. You have to have a legal fence as your highway fence. And so there was a multi-million-dollar judgment for the family in that situation against the Department of Transportation, and that was upheld on appeal. If the land is sold or the tenant dies before the crop is harvested, what happens here? Well, and if a crop is growing at the time of lease termination, the tenant is going to get the crop at the termination. It's not the tenant's fault. But of course, we can change all of this in a written lease. Written lease is a contract, so it's going to be governed by contract law. We can change presumptions of state law by a written contract. Be careful with the written language. You don't want to do it yourself. There are boilerplate forms, and they're good to an extent, but often facts are unique to particular situations, and you may need unique provisions to be put into that boilerplate form. You can start with a boilerplate form, but don't end there. So I'll skip the balance of that. If either the tenant, now back to this issue, if either the tenant or the landlord dies during the term of the lease and you don't have it in writing, of course, if the landlord dies, it's pretty easy. The heirs assume the lease. If the tenant dies, then we get into the personal services contract issue. And here's a case out of Illinois. Parties entered into an oral lease of farmland. After 20 years, tenant died. Can the tenant's heirs assume the lease? And the answer is, well, the lease, in this instance, they said it's a personal services contract. The landlord was contracting for the personal services unique to the tenant. Tenant died. And so the reason for the lease exists no more. And so the heirs are not entitled to continue to lease the property until they get statutory notice of termination. Of course, they can continue the lease if there's a growing crop at that time and harvest that crop. But once they do that, it's over. They can't sit there and wait until they get the statutory notice of termination. And we had a case on this in Kansas a few years ago. I think it came out of Coffee County. And we got a little bit different result in Kansas. They didn't quite say that, didn't quite precisely follow the Illinois approach in Ames against Saylor, but they really got to the same result without saying that they did. In Nebraska, Nebraska has no statutory notice of termination requirement. It's pretty unique. There's nothing in the books in Kansas in the code that says, like we have in Kansas, that you have to give notice at least 30 days before March 1 in writing, specifying March 1 as the termination date. But here's how they dealt with it. In Wilson against Fieldgrove, there was an oral cash lease and the tenant died. Now, there's no statutory requirement, but the common law requirement under case law in Nebraska is 6 months. You have to give 6 months notice. And that's a big difference by a bordering state, 6 months notice. And that's the same thing in Iowa, 6 months notice prior to March 1. And they did say sharecrop leases are generally personal service contracts. But as I said earlier, Nebraska says not so fast with cash leases. Those don't die with the tenant because that's not a personal services contract. You're just getting a set amount of dollars. Your income's not dependent on how good a job that tenant does. Landlord, you're going to get X, no matter what happens to the crop, no matter how good the tenant is as a farmer, you still get X. And that's not a personal services contract. So some courts have drawn that distinction. That's just a key point to keep in mind. Now, again, you can override all of that with a proper writing. If the landlord dies and there's a growing crop in the field, if the landlord owns a fee simple, now here's where we distinguish the ownership interest of the landlord. If the landlord owns a fee simple, that means they own the entire property right, property interest outright for life, of potentially infinite duration. So they've got the full ownership. Then the heirs just simply succeed to the landlord's share of the crop. So that's going to go to the heirs of the landlord, and they will have the responsibility to terminate the lease if they want to, renegotiate the lease. They become the landlord. If the landlord owns a life estate, and there are a lot of these out there in Kansas agriculture and in agriculture in general, his first spouse has died, leaves the surviving spouse a life estate with remainder going probably to the children. That's typically the estate plan. The issue is going to be who gets the deceased landlord's share under a crop share or livestock share lease. Does that become property of the decedent's estate, or does it go to the holder or holders of the remainder interest? Now that's an interesting one, because if it goes to the estate, then we read the landlord's will or trust to determine who that property and this interest here, the crop, would go to. That may be different than the remainder holders. That may not be the same people as the remainder holders. So that's a real question that we can get around that problem by specifying who takes the landlord's share of a share crop or livestock share lease if the landlord dies. We can put that in writing. But if not, and the landlord owns a life estate, then we have to look to how state law treats that. Now in Kansas, growing crops are generally held to be personal property. That means the landlord's crop share becomes personal property of the landlord's estate. It doesn't go to the remainder holders. It's going to go in the estate. Now, it might go to the remainder holders if they're the same people that are the heirs of the deceased landlord. Okay, but it may not be. Colorado and Oregon treat that differently, where they say that growing crops are not personal property of the landlord's estate. So they would say it goes to the holder of the remainder interest. So that's one of those things. We tend not to think about that. Non-lawyers don't think about those things. In fact, a lot of lawyers don't even think about those types of things when they're drafting leases. But that is something. We don't know when death is going to occur, and it may happen when there is a growing crop in the field. So keep that in mind. That's one of those unique issues that's out there. Chuck talked about controlling noxious weeds. Yeah, the party that either owns or supervises the property is responsible. Well, that landlord owns it and the tenant possesses it. So both of them are responsible. Kansas did dramatically change the noxious weed statute in 2018. And we've got a new list of noxious weeds as of about 3 weeks ago. This just started in 2021. Basically, and it's kind of funny, one of the longest pieces of legislation in the 2018 session was the noxious weed legislation. Went on for page and page and page. I kind of got a kick out of that, reading that. But that old list has expired. We have a new list and more control and right to specify what are noxious weeds at the county level. And so the state, and I think that's very wise for the state to do that. I had been pushing legislators for a number of years to do that. Kick it back to the counties. What makes sense in Wallace County may not make sense in Bourbon County, for example. The state is too vast geographically. You have different problems, west to east, north to south. So let's let the counties have more control of this. So I'm not going to go through it with you, but what I would point out to you is pay attention to what your counties are doing. We do have new rules on noxious weeds that are in place now, but it doesn't change the underlying rule in terms of a lease situation, who the party is that's responsible to control those weeds. Permanent improvements, the general rule is if it's a permanent improvement, and the tenant puts it on there, that's going to go to the landlord when that lease terminates, unless there's a written lease that says that that still belongs to the tenant. But the question, of course, it's going to be a factual one. Did the improvement become fixed to the real estate? Is it a part of the real estate or not? Liability. What if somebody comes on the premises and injures themselves? It's a tort type situation. Well, general rule is tenant's liable because liability follows possession. So the tenant has possession and control, but the landlord can become liable if they retain control over certain parts of the property and injury occurred as a result of that. That can bring the landlord into play. Also, I would tell you that if the tenant is creating a nuisance, there was an interesting Iowa case, probably about 10 years ago now, where, and as you can imagine, it was in Northwest Iowa and it involved hog manure. And the tenant on the property was spreading hog manure. He was entitled to do so under the lease. That was part of the deal here, because that conveys a benefit to the landlord, getting that manure on the farm ground. And he was spreading it too close to a neighbor. There actually were 2 tracts that were leased, and the neighbor was right in between the 2 tracts that the landlord owned that the tenant was farming and spreading manure on. And it became a real nuisance issue. And the landowner in the middle that was complaining talked to the tenant first and said, spread this elsewhere. It's too close to my house. It's really creating a problem. Or knife it and immediately do something. Well, the tenant wouldn't listen to him. So that party went to the landlord and complained. The landlord said, it's not my problem. Tenant's responsible for what happens on the premises. And the Iowa Supreme Court said, landlord, it is your problem. When you know that your tenant is creating a nuisance that's harming the rights of somebody else to enjoy their property, then you can become liable. And the landlord was actually on notice. And so that was an interesting case. Assignment, again, as I said, tenant cannot assign or transfer the lease without the landlord's permission. That doesn't necessarily wipe out the lease. It makes it voidable. That's a fancy dancy legal term. But what that means is that the landlord then has the right to re-enter the premises, take possession, and remove the new tenant upon 10 days notice. Okay, the one that's been subleased to. So it's not voidable, or it's not terminated, it's voidable. And that does give the landlord the right to re-enter, take possession, remove that subtenant out after giving 10 days notice. And you don't want to get into that kind of stuff. You want to deal with that in a written lease agreement. As Chuck mentioned, normally when land is sold, and I will warn you, a lot of real estate people and auctioneers do not properly state this, and it creates confusion. The new owner normally takes the property subject to the existing lease, unless, again, that lease is in writing and says something different. So one of the things when you buy land, you always want to make sure to ask the question, is there a lease on this? Check the land records to see if it happens to be recorded on the land records. And if you do discover that there is a written lease, demand to see a copy of it, because you want to address that issue of whether that was specified in the lease, who has control of the property if it is to be sold. The tenant doesn't have to agree to be the tenant of the new owner. And so the tenant can say, all right, I'm out. I don't want to be the tenant of the new owner. But if the tenant already paid rent, there's no need to pay the new owner for the same time period. And we get these questions too on the rental issue. Sometimes the new owner will be saying, well, now you owe rent. Well, tenant already paid for a particular period of time. And if that overlaps the new owner coming in, the tenant doesn't have to pay for that time period that's already been paid for. Now, that's where you may want to, before closing, have the prior owner and the new owner and the tenant negotiate something to work out the economics of that. If not, you can get into some issues. The selling landlord can require the tenant to pay for any past due rent caused by the tenant's abandonment of the property before the sale. Sometimes that happens too. If the tenant stops paying rent, what happens? Well, if they're late 3 months, so they have a time frame when the rent has to be paid. Then you wait 3 months after that. Then the landlord can take action to start to terminate the lease, but they have to give 10 days written notice first, because the tenant has the right to come up with the funds during those 10 days. If they fail that test and they haven't paid the rent, then the unpaid rent gives the landlord a lien on crops. And I put crops in quotes specifically because the statute says crops. So that means that the type of lease might matter. So it's crops growing on or harvested from the leased premises, which means if the tenant then harvests the crop and markets the crop, then the landlord has a landlord's lien on the landlord's share and can get paid. That's a superior lien, can get paid before the tenant's creditors get paid. So and what that means is it's superior to prior existing security interest on crops. It attaches only to the landlord's share of the crop in a crop share situation. And the landlord has a right to possess that crop until that rent gets paid. If it's a cash rent, it's not an automatic landlord's lien. The landlord has to file a security interest and financing statement, is what they have to file, to perfect that lien. So there's an extra step that has to be taken. If the tenant hasn't paid and it's a cash lease situation, the tenant has to file a financing statement to perfect that interest. Okay. Certain contracts have to be in writing to be enforceable. The exception to that is contracts that can be performed within a year, and that's why in Kansas, oral ag leases are presumed to run from year to year. Okay, if you want to terminate, state law controls. If you have land in other states, their termination statutes will not necessarily be the same as Kansas. I already talked about Nebraska, Missouri, and Iowa, and Colorado, and Oklahoma are all different than Kansas. And it may tie to a crop or cropping seasons. And pasture lease rules may be different from crop lease rules in some states, not in Kansas. Now, it used to be different in Kansas, but a number of years ago, probably 20 years ago or so, the pasture lease termination rules were made the same as the crop lease termination rules. Okay, and as Chuck said, that can be perilous in the livestock situation, because that oral lease is going to be presumed to run from year to year. If you don't give proper notice, it's going to continue for another year. That's a different, we have different concerns in a pasture lease situation than if it's a crop lease situation, perhaps. So just keep that in mind. Okay, serving notice of termination, Chuck mentioned that. Here you see that again. And that age 12 one is funny. I've actually seen that happen a couple of times. But if you can't find anybody over age 12, the statutes, well, we do have a case. It's the Guerin case in 2001, says, well, just post it in a conspicuous place. And that means that's fact dependent in terms of what's conspicuous. Conspicuous means a place where everybody can see it and where the tenant might be expected to see it at. So we don't want to have to get to that point. This is another way or another reason a written ag lease can be better, because you can avoid these types of situations and avoid that problem. Let's talk a little bit about oil and gas leases. This is, we have these in Kansas also, and particularly where many of you are at, you might be in an oil and gas lease. This is a conveyance of the mineral interest by sale of the lease. So oil and gas, while in the ground, are considered to be part of the real estate. That means the oil and gas those rights can be conveyed by a real estate deed or a mineral deed. Those mineral interests can be severed from the surface. So we can have a surface tenant, we can have a subsurface tenant, and then we have the landlord. So we end up with 3 parties. And that can create some issues. We want to make sure we've got everything in writing so that the subsurface tenant's rights don't interfere with the crop tenant's rights or the pasture tenant's rights. And then when that land is sold, if no reservation of the minerals is made, the presumption is that no severance has occurred and that you're getting the mineral rights along with the surface rights. But a lot of owners prefer to retain ownership of the surface and then just simply lease out the mineral rights. Majority owners of the mineral interest are protected if one or more of the holders of the minority interest become unknown. So this bears on the issue of who has the power to sell or lease the land, and how does that impact the owners of the mineral interest. The trial courts, the district courts in Kansas will simply appoint a receiver who can negotiate for the sale or lease of an interest. If you own less than an outright fee simple absolute interest in the property, then you usually, those owners are joined in executing an oil and gas lease. So it's not just the fee owners, it may be somebody that has a remainder interest. We usually include them when an oil and gas lease is executed. It's all owners of interest in the property. When you have an oil and gas subsurface tenant, what if the surface is leased for crop production? And we get into the damage issue caused by drilling, for example, or exploration. Well, the crop tenant could recover damages from the landlord for damage to the tenant's crops or for interference with the tenant's use of the surface by the oil and gas operator. So the landlord could reserve the right, for example, to lease for oil and gas, or they could have the oil and gas lease made subordinate to the surface for drilling. And if that ag lease is the first one that's granted, then the subsurface tenant, and by ag I mean the surface tenant, then if that's the lease that's granted first, then the subsurface tenant may need to get the ag lease tenant's permission before drilling can commence. And so when you have these types of situations, that's another type of paragraph and a language that we want to include in our crop leases and in our pasture leases. If there's the potential for oil and gas production, how are the parties' relationships outlined in a written lease? Use of the surface. A lessee typically has the right to enter the land and explore for minerals, or drill is what I mean there, and begin production if minerals are discovered. That includes the implied right to use as much of the surface as is reasonably necessary to exercise development rights. So we get into this battle here of whose rights are subordinate to whose other rights. And basically the subsurface tenant can use as much of the surface as is reasonably necessary for their development right of the mineral interest, putting pipelines in and building roads and constructing buildings. So you may need additional contract language that really pins the subsurface tenant down on where drilling is to occur, where wells are to be located, where any structures are to be placed. You want to put that in a written lease that really is fairly narrowly drafted to well define where those types of things can be. Also, you might want a provision requiring the lessor, the landlord's approval concerning the location of wells, structures, and roads. So another thing to think about. Water use clauses tend to be pretty broad with respect to oil and gas leases. Landowner might want to limit the use of water by the operator. Perhaps we want to reserve all the fresh water or limit the operator's use to such amounts as won't interfere with the landowner's usage, or limit usage to primary production activities. But we don't want to interfere with the landowner's use or intended use for irrigation purposes. So we want a clause in there that says that any drilling that the subsurface tenant does is not to interfere with irrigation practices during irrigation season and until the crops are harvested. That's a bigger issue out in western Kansas, not so much in southeast Kansas, but you can still get that occasionally in your part of the state. Surface damage clauses, you got to think this one through. This is what protects the landowner against damage to the surface. And if you don't have this type of clause, then the tenant has no liability except for excessive use or negligence, really bad practices. And that's, we don't want to have to get that far down the road before we can recover anything. And you may want a clause requiring the subsurface tenant to restore the surface to its original condition after they've drilled, for example. Now, the state in Kansas does this. Requires the lessee to remove all equipment and structures and leave the land in original condition upon abandonment of an oil or gas well. But I think it's still a great idea to put that in a written lease itself. Plus, you might have another concern with respect to the location of pipelines. We don't want those to interfere with farming activities, and make sure they're buried far enough below the depth that farm machinery could cause a problem with it. lot of times the language is plow depth, when you get them beneath plow depth. And we had an 87 case, Trotter against Wells Petroleum, where you had in Kansas, where you had an individual that bought land with oil production, leased the land out to Wells Petroleum Company, and the defendant came in, the company came in, buried a pipeline under the pasture, and in the process damaged the pasture grass. And the lease contract had language that they thought would cover this. It says, lessee shall bury his pipe below plow depth and promptly cover and level all pits, and lessee shall pay all damages caused by its operations to growing crops. Okay, that sounds fine, but this was a pasture lease situation. The growing crop language and plow depth language really doesn't have anything to do with respect to a pasture lease. And so is a pasture lease, is that damage provision applicable in a pasture lease situation? And the court said, no, it's not. The Kansas Court of Appeals. They didn't cultivate the land, they didn't work the pasture, and cattle grazing is not the same thing as cultivation. And so referring to plow depth and growing crops, well, that's what applies in a crop lease situation, not in a pasture lease situation. So bad result, but we got to think those things through and do a better job in protecting clients' rights in those situations. And these are just some common contract clauses in oil and gas leases. And in the oil and gas context, some of the leases require written notice of termination. I think that's a good idea also. Okay, there are various other types of clauses that are unique to oil and gas leases. On the royalty side of things, the landowner shares usually 1/8 to 3/16 of gross production. So the operator usually pays all the expenses of exploring and producing oil and gas from the operator's share. That's the working interest. And for oil, a royalty usually is paid in kind, and the lessee buys the landowner's share based on market value. If it's gas, it's usually paid under a long-term contract. Storage provision, payment can be made to the owner for storage, even in the absence of drilling. Now, you might, that might be a low payment because there could be interference with surface use, but the lease might have language in it that allows the lease to remain in effect so long as gas storage continues. And so you've got a lot of flexibility there. At least the tenant does in continuation of the lease, but no compensation to the landlord usually is the way it goes with respect to use in gas storage. So that's something we may want to have a separate agreement separate from the actual lease between the parties. Okay, then the surrender clause, and let me throw one other in here just to kind of wrap up. Wind energy leases. Have a list of just a few suggested provisions here. What part of the land is subject to the agreement? What events trigger early termination? Is there an automatic renewal clause? There will be. When must construction commence? So in other words, how much time do you give a wind energy company under their prospect clause before they've got to make a decision as to whether they're going to do something? Are you properly compensated for land use restrictions that are placed on your use of your farm ground if wind towers are put up? What's your rights to use the property? How does it impact the farm program benefits? If you've got some land that's taken out of production, for example, what's your liability for actions to third parties? Hunting leases, real quick. These aren't really leases. We refer to them as leases, but they're really not. It's a use right. You're giving somebody a short-term right to use your property for hunting. We want to get these things in writing, particularly with respect to the liability issue. And we want to absolve ourselves as landowners from liability. And often a state recreational use statute will apply to provide some protection as long as you're not compensated. Now, in Kansas, an ag owner can receive compensation and still have the protection provided by the recreational use statute. A non-farmer cannot. But hunting leases, these are best to be put in a separate agreement, separate from the farm lease, and give some thought as to how you want that structured. And as I said, it's not really a lease, it's a license to use the property for hunting purposes. And we can define those rights in a written contract, and that's the key, where we're identifying the parties describing the property, listing out the type of hunting allowed, when it's allowed, perhaps the type of weapons that can be used by caliber, when does it terminate, can it be renewed, or do we have to do another agreement the following hunting season, and put liability waiver and indemnification clause in there, and set up your payment terms, and make sure that your comprehensive farm liability insurance policy also deals with this. And if it doesn't, then you want to make sure you've got your language in here that protects you to the best degree that you can in a separate written agreement. Okay, with that, James, I'll turn it back over to you. And I do thank you for the invitation today. I'm not sure I really like the Zoom thing that we're doing. I prefer to be there in person with you, but it's what we're doing these days. Hopefully we can get back to normal here soon, but feel free to contact me anytime. It doesn't have to be in caps. My email does not have to be in caps. That's just the way I wrote that there. And follow me on Twitter. I do give particularly tax quick developments. We'll first go to Twitter when IRS comes out with something, or there's a breaking development on PPP, as there was about 2 weeks ago. That was a great benefit for farmers. They're opening PPP up for all farmers, even if you're showing a net loss on the return. Okay. All right, James.
Thank you. Do you have time for a question or two, if there are any?
I have a question texted in. If someone's needing an attorney for lease agreements or other ag-related topics, is there a database that you go to find one for a lawyer?
Okay, it's a bit hard for me to hear because of the echo, but I think the question was, do I need an attorney to draft a lease agreement for me? Is that correct, James?
Well, she was wondering, is there like a database of attorneys to help draft leases?
Oh.
Is there a list?
Well, there's not necessarily a database. And one of the things in Kansas, the Bar Association really is kind of tough on attorneys advertising specialties, but people like me know who would be good to refer you to. So feel free to ask me that question. I can get you pointed in the right direction.
Thank you.
Mm-hmm.
I'll see anything else from the chat. So, yeah, thank you so much, Roger, for speaking to us and helping us through these details. I really like law and the little details and all the case law. It's really interesting. So, thank you so
Good.
much.
Thanks for having me, James. I really appreciate it. Anytime.
So next up, me and Mindy are going to cover a little bit of, we basically tried to have a survey. Mindy did the vast majority of the work, so I'll caveat this. I was pretty much riding on her coattails the entire time, but we're going to have the, just real brief going through the results of that survey data.
Yeah. Okay. Thanks, James. So, really, the credit shouldn't go to me because I kind of piggyback off of another district that did some of these, and they've been doing theirs for a lot longer. So, of course, their data is much larger, their data set is. Let's see if I can find my presentation. Okay. Is that showing on the Zoom? No, just a minute. I can share my screen from here, if I can remember how to do that. Yeah, you can share your screen. Okay. All right. I hope that bar will go away there in a second. Okay, so for those of you that may not know me, I'm Wendy Powell. I'm the livestock production agent here for the district. I live in Montgomery County. I'm a small cow-calf operation over there. I'm out in the Altamont office, so get to see a lot of different things. Our 2020 pasture lease survey rolled out in late November, and so we were collecting data responses in December and early January, actually late January too, yesterday even. So lots of people were interested in that, and I really want to reiterate what Chuck was saying earlier today. There's lots of people that want to know what pasture lease is going for, but there's not a lot of people that want to share. So we definitely ran into that. I think I'm gonna go and take this off. I think we've found some places we can improve the survey. So I just want to preface this presentation with, we have a very small amount of data, but I'm going to share with you what we did get. Okay, I think I'm looking at the wrong screen on my deal. There we go. Okay, so here's a list of what all I tried to cover in that survey, and that bar is not going away, so you can't see all of those bullets. But anyways, lots of different things was in the survey, only because there's lots of different things that go into a pasture lease contract. And these are all things that are going to impact the price. So all of these you have to take into consideration whenever you're trying to figure a rental rate. Oh, if there's another factor that you can think of that is for more, that would apply to more than one lease, just let me know. I'm happy to try to make this survey more user-friendly as well as more applicable to our area. Just some information about the state of cattle inventory in Kansas. So we have about a third of the cattle in the state here in Wildcat District in our 4 counties. So you can see the breakdown there. And this is from 2017 when the last ag census was done. On our responses, I actually had 43 responses, but of those 43, there was several that had no data whatsoever. So this was an online survey sent by email, and folks were able to call into the extension office if they wanted a hard copy sent to them, or they could chat with one of us, or just somehow get word to us that they were interested in taking this by paper copy, and we would get one to them. I did not have anybody request a paper copy, so we do have room for improvement with our distribution next year. 3,462 emails were sent, and that email included the link to go to the survey as well as the phone number to the office and contact information for us for the request for hard copies. Like I said, 16 of the surveys were started, but there was no data entered. So it's possible that somebody started the survey and then got distracted by screaming small children. That was me probably. Lots of different scenarios there, or simply lost interest there. So we got 23 usable surveys, and I have broken down there the counties. The blank there that just means that they filled out the rest of the survey, but they left their county blank. So they're somewhere in the district. Okay. So the other thing to keep in mind with all of this data is some sections were only answered in parts. So when I asked about the price per acre per year or whatnot, they might have filled that out, but they might not have told me, what species they were grazing. Or they might have told me what species they were grazing, but they didn't give me any price. Going back to that, everybody wants to know, but nobody wants to share situation. So we had 6 usable surveys to talk about the price per acre per year. So you can see there that we have a huge range. And these 6 all had the same things in common that I listed down there. And there is not another bullet after that last along the fourth one. So these were all introduced forages, fescue or Bermuda. I think most of them were fescue, but there was some Bermuda mixed in. And these were all mixed with native. Some of them listed little blue and switchgrass, some of them listed all 4 of the big 4 natives, but they were all mixed with native. These all had their operators unrelated to the landowner. I thought that was interesting. And then they broke down how often they renegotiated this contract. And of these, 2 were written and 4 were oral. Any questions so far on that? Okay, so here's just some pie. You know, we just had lunch, so lots of information here. I know here in person we can't see the text on that green one. The bottom one that's the unrelated category. 13 respondents are unrelated to the other party. I forgot to preface this. Landowners and tenants can answer this survey. They all had the same survey. So some of them are speaking from that standpoint, some of them are the tenant. Some of the landowners didn't always know like what time of year the tenant likes to wean calves or what the body condition score of their cows were. So that might be something that we improve on next year. I thought it was interesting, our longevity on that. A lot of them were fairly new, but I did have some respondents that have been in their contract or in their agreement for a while. So, like I mentioned, we've got some ideas to improve this information. And if you know of someone that did not take part in that this year, encourage them to do that next year so that we can present data to you and really be able to answer the question when it comes into the office, how much should my pasture go for? We can give them viable information instead of just well, somewhere between $16 and $50 an acre. That would be really helpful. So, questions? Yes.
Okay. You said you sent out about 3,000 requests for survey. Is one of your questions, if you don't qualify, if your operation doesn't qualify, a lot of the people that have referred you to the neighbor, which is taking a little more detail, but
Yeah.
I don't, because it wouldn't have to fill out the survey because it was weird. But I thought it was could name 10 people that actually lease pasture ground.
So I can't say for sure what the verbiage was on that, but I'm fairly certain, yes, share with your neighbors. Kind of like the registration with this meeting is if you know of someone, spread the word. We tried not to make it exclusive, and I think James is probably going to touch on this later, but the hard copies, you know, the cost of mailing out, then the question becomes if we mail them out, are we going to get them back? And so really the best way to get the information to you, you need to let us know. If emails and social media posts don't work, how would you like that information given to you? A QR code at the feed store registration or feed store sales desk? Something I thought of at the end of the program, but we are definitely willing to hear your ideas. All right, thank you.
Here, I'll need your help. Oh. I'm gonna be super quick, so hang on a second. Pretty much the exact same thing. It's gonna be fast because it's the exact same thing as Wendy's, except it's crops instead of pasture. And so the survey results, like so the survey, like Wendy said, survey period was between December 2020 to January, so this month, last month. For the crop side, I only had 5 completed surveys. So I cannot give you any data because 5 isn't even statistically accurate or anything. So 1 Labette, 1 Wilson, and 3 in Crawford. That's not enough to actually give you any legitimate data, but I'm still going to talk about some of the state data. So 5, all of them considered to be upland. I asked if they were, bottomland or upland. That's one thing that the state does not, the NASS does not differentiate, which is of course the biggest component between pricing for cropland is between those two. There was only 1 written, and all the rest of them were oral leases, which is of course the most common, and none of them were actually family contracts. So crop share, the 3 that were in crop share, they were all 2/3 and 1/3, and that is nearly all crops share in Southeast Kansas are going to be that 1/3, 2/3. That's from the state data. It's pretty much, that's the way we split it here. Other parts of the state, they do a little bit of 2/3, 2/5, 3/5. Here we don't. They all shared fertilizer costs, but they didn't necessarily share the herbicide pesticide cost. And that is actually also common throughout the state. So fertilizer is commonly shared, but that doesn't necessarily mean that the herbicides and pesticides go the same way. But like Chuck said, when you have some sort of input that affects the crop yield, basically, it kind of needs to be part of the crop share. And so really any input that affects it is part of that 1/3, 2/3, and that includes the governmental programs that you get on the other end as well. So, but that just depends on how the handshake went. So of the 2 that were from Crawford, I don't want to give any specifics, but they were both in the 60s, which is about what you would expect. So for Southeast Kansas, the range is from $30 to $60, 30 to 90 of all the various leases that they collected, the NASS collected from Southeast Kansas. And in Crawford, that's from the 60s, Neosho, 50s, 51. I would say that's probably about the average that I've heard of anecdotally. All right, so probably somewhere in the upper 50s to the 60s for farmland. A lot of that's probably upland because bottomland is usually owned, but not always. Can't really be any more specific than that because we just don't have the data. So from the state data, some of the inserts I took out is how often do those cap rates change? And so I found this really interesting that some of them, ideally speaking, change almost every year, 15% do. However, 1/4 of them haven't changed for over 20 years. They haven't renegotiated their cash rental amounts for over 20 years. Probably not terribly accurate anymore. So just keep that in mind. Really, ideally speaking, you want to do what Chuck said, at least every 5 years, you want to update your rental rates. As for cash rent to crop share, a lot of people ask, what should I do? That really depends on a lot of factors. Often not, I say that if you have an idea of farming, if you basically grew up on the farm, but you're not really a farmer anymore, maybe you've retired, but you still have a concept, you probably want to do crop share. Over time, it's going to be your bigger payment, and it gives a little bit of insurance between you, the landlord, and the tenant. However, if you have no really idea, you're an out-of-state landowner, maybe you're older, you kind of need a more stable income, you don't have an idea about farming anymore, you probably want to do a cash rate. So that way you absolutely know how much you're going to get, and you have no liability within the market. And so next year, I think we need to have a longer collection time period. We might do some mass mailings, but of course, if you do a mass mailings, you're going to have the stamp on there. It's going to be a lot of money. So we're not exactly sure how to do that yet, but in the next couple of years, we're hoping to do this again, kind of reiterate some of the things, maybe change some of the leases. So that's pretty much it. That's kind of what we have found so far. some very introductory data, and hopefully in years to come, we'll have